The direct costs of resolving construction disputes amount to between $560 and $840 million per year. When added to the avoidable costs of disputes, such as delay and opportunity costs, total waste exceeds $7 billion annually. Conflict is inevitable, but disputes and their protracted resolutions are optional. Dispute review boards are one of the most successful forms of dispute avoidance processes that have evolved to embrace the philosophy that prevention is better than cure when it comes to construction, conflict, and disputes. So let's have a look at how they work. Meet Ken and Sepov. Ken agrees to renovate and transform an old boiler house for Sepov to include an art gallery, a restaurant, and an underground car park, all in 130 days. Before construction starts, they agree to maximise the chances of the project not ending up in arbitration or litigation by using a DRB. A DRB is made up of 3 neutral third-party experts who are jointly appointed by the contracting parties. Ken nominates Larry, a senior engineer experienced in renovating industrial buildings. Sepov chooses Gary, who has 35 years' experience in the construction of major projects. And both Larry and Gary then nominate Professor Mary, who is an expert in construction law and in the conduct and operation of DRBs, as the third member and chair of the DRB. Before construction starts, the DRB asks Ken and Sepov to prepare a joint presentation covering the potential sources of conflict that may be encountered on the project, and what steps they propose to take to reduce the possibility of these hotspots from erupting. Ken and Sepov work together all night preparing their presentation. They both proudly present to the board the very next day. This task allows Ken and Sepov to learn early on how to communicate to each other and enables them to focus their energy on avoiding disputes. As Albert Einstein once said, a country cannot simultaneously prepare and prevent war. At day 20, everything is ahead of schedule. The parties are working well together and communicating openly. There is no animosity or opportunistic behaviour, as the parties respect each other and want to preserve and enhance their reputation, knowing that the DRB members are observing the progress of the project. On day 40, the DRB conducts a routine site inspection and notices tension between the parties. Ken discovers more hard rock than he anticipated when excavating ground for the underground car park. Ken tells Sepov that this has the potential to significantly delay the works. The only way this can be avoided is if more excavators are brought on site and more staff used to keep the project on schedule. Sepov believes that he should not have to pay for the extra costs or grant an extension of time, as any geotechnical engineer would have been able to foresee this amount of hard rock, and therefore Ken should also have been able to. In the middle of their conversation, Ken and Sepov are interrupted by the DRB, which knows that this has the potential to become a costly dispute. They ask Ken and Sepov whether they wish to refer this issue to the DRB for quick resolution. A full-blown dispute being played out in court, along with its immense costs, worried both Ken and Sepov, so they both agree to refer the issue to the DRB. After both parties present their arguments to the DRB members discuss amongst themselves the merits of each party's position. The parties are using an AS 4000 standard form contract, and Mary guides Larry and Gary through the latent conditions provisions. Mary notes that a latent condition is a physical condition that is materially different from the physical conditions which should reasonably have been anticipated by a competent contractor. She explains to Larry and Gary that while Sepoff's position appears to be that any geotechnical engineer could have anticipated this quantity of hard rock, the test set out in clause 25.1 of the contract is whether the contractor could have anticipated the conditions. Mary also refers to a couple of court decisions that affirmed that the relevant skill level is that of a competent contractor, not a geotechnical engineer. Gary says that in his experience, no contractor could have foreseen this amount of hard rock in this location. Larry agrees. The DRB provides a non-binding recommendation to the parties, which provides an interpretation of the latent condition clause in the contract and explains the law about unforeseen ground conditions. It also explains why Ken should not be held liable. Knowing that the recommendation is made by respected and experienced professionals, Sepoff agrees to accept the DRB's recommendation. The contemporaneous resolution of construction conflicts and disputes ensures that hostilities between all project personnel are kept to an absolute minimum, which is a key factor in ensuring that the project stays on schedule and disputes avoided. The entire legal profession, lawyers, judges, law teachers, has become so mesmerised with the stimulation of courtroom contest that we tend to forget that we ought to be healers of conflict.